Welcome to Consumer Law. What is it good for? Where we look at, consider, and try to answer frequently asked questions that come to us at Stormcatcher Law, either via our free advice helpline or from our clients. And in this episode, I'm going to look at new and used car warranties. I'm going to look at 4 points. Firstly, what is the relationship between warranties and the law? Secondly, why do warranty repairs take so long? Thirdly, what happens if warranty repairs don't succeed? And fourthly, can I reject a car if the warranty repair takes too long? Now, these points have come from many questions over the last couple of weeks and in general, and this video particularly applies to those people that have a legal claim for a faulty vehicle, for example, and have been directed towards or have had repairs carried out under warranty. So I'm going to give you a bit of background as usual. In new car main dealerships, most of the revenue that comes into that business comes from the service department, from servicing and repairing vehicles. And this, guess what, includes warranty work. So in short, the dealership gets paid by the warranty company to fix faulty cars. So it's not difficult to see why a main dealership would want to direct your faulty car complaint towards the warranty. In second-hand car dealerships, the idea is very similar, but rather than them being paid to fix the faulty cars, although some of them will do that, it's more about the warranty company paying for the cost of repairs rather than them. None of which seems unreasonable. However, this process is indiscriminate, meaning all, if not the majority, of faulty car complaints are processed as warranty claims, rather than people categorizing those that are statutory complaints, legal complaints, and those that aren't and are warranty complaints. And that's where the problem starts. So I'm going to go through each of those questions now to explain this in more depth. First, what is the relationship between warranties and the law? In short, where the law applies, the law will trump the warranty. Your legal rights are higher than anything to do with the warranty. What do I mean by that? So if your vehicle, for example, was to become faulty within 6 months of delivery or has a manufacturing defect, you have no obligation to make a warranty claim. Instead, you have the right to request that the supplying dealer or the finance company, if you bought a car on finance, repair your vehicle or pay the cost of repairing your vehicle. Now, you may hear some car dealers and finance companies and even some of their lawyers explain that, or tell you more importantly, that by not making a warranty claim, you fail to mitigate your losses and you cannot claim that you have not attempted to mitigate. Whilst the rule of mitigation is true, it's not true in this particular circumstances. You can effectively choose whether to make a warranty claim or to claim off of the supplier without impacting at all your obligations to mitigate your claims. You could potentially have a hybrid scenario where your warranty claim limit is insufficient, so it doesn't cover the full amount of the repair, and that you would then perhaps be able to claim the difference between the warranty cover and the cost from the supplying dealer or the finance company. In the case of a new car, where you have a situation where the manufacturer is making a goodwill contribution towards the repair. We often see this in cases of replacement engines, DPF cases, and so on and so forth. You may well be able to claim that difference between that contribution and the repair cost back from the supplying dealer. But I do stress that these are general rules and that you should get bespoke legal advice in order to make sure that everything applies to your case. So just give us a call. Next question. Why is it that warranty repairs take so long? And this again often applies, although not exclusively, to main dealerships. And the answer to that is that your warranty will agree to pay the cost of parts and labour, but the repairs are not time sensitive, meaning that there is no specific period of time in which the repair has to be completed. Now, if we contrast that with the law, we know that repairs have to be completed within a reasonable period of time and without causing you, the customer, significant inconvenience. So you can see that it would be beneficial to you in those circumstances to elect to have your statutory or legal claim rather than your warranty claim, because you could find yourself in a very long queue getting nowhere fast. Thirdly, what happens if warranty repairs don't succeed? Now, warranty repairs are usually carried out in stages. They're not quite trial and error, but they're on that sort of line. The reason is that a warranty company understandably will only agree to fork out for those things that are absolutely necessary. So the warranty company will say, for example, we want you to replace, and we will pay the cost of replacing the turbo before we agree to replace the whole engine. So whilst that's sensible, it doesn't help you in terms of resolving the wider problems. If the repair doesn't fail, so in that scenario I just explained, if the turbo does not cure the problem you're having with the engine, then simply another warranty claim would be made. If we again contrast that with the law, which only allows one attempt to bring the vehicle into conformity to the contract, which means one opportunity to make the vehicle as it should have been from the outset, no second bite of the cherry. After that, if that attempt does not succeed, then it's likely your right to reject that vehicle will arise. And we can see again the difference. The warranty has more than one bite of the cherry. The law doesn't allow that. So if you want to not be given the runaround, and you want your vehicle to be either repaired or replaced, then your legal rights are going to be better for you than your warranty. Finally, the question, can I reject the vehicle if the warranty repairs are taking too long? The answer to that is possibly. Possibly. If you have complained to the supplying dealer or the finance company in the first instance about the fault, and that they then direct you towards the warranty and suggest that you make a warranty claim rather than dealing with it like a faulty car complaint, it is likely that that will be considered as giving the seller the opportunity to repair the vehicle, which they didn't take. And because of this, and your right to have, your legal right to have the vehicle repaired, that you could then potentially either take the vehicle elsewhere to have it repaired, or the law may view that as a refusal to attempt to repair the vehicle, and again, your right to reject may arise. So in summary, if you're in a position where the vehicle has become defective within 6 months, or it has a manufacturing defect which may occur after that 6-month period, or there's been a long line of similar repairs or repairs to the vehicle that date back from close to when you've perhaps bought the vehicle, you may well have a legal claim. So check that first. Once you've established that, then make sure that you inform your supplying dealership or your finance company of your complaint, and you must do that in writing. If you go through that stage, first of all, you're always going to be protected. If you then say or find out that the dealership or the dealer group can repair your vehicle quickly and effectively under warranty, and you're happy for that to happen, you can get your car back and a courtesy car in a short period of time, no problem. But don't be persuaded or forced into a long queue of other warranty complainants, which particularly happens when we've got recalls, for example, if you've got legal rights. I hope this has been of interest to you. If you have any specific questions or you need specific legal advice about your problems, please give us a call on 0333 700 7676. Thanks for watching.